Welcome to the Lord GH channel and welcome to our final episode on general negligence. Today we are looking at the third element to establishing an action of general negligence, which is the resultant damage. Let's begin by examining the two schools of thought on resultant damage under general negligence. There are two schools of thought as far as the question of damage which completes the formula is concerned, and for which the defendant must therefore be held liable. The first school, or test, extends liability to all physiological consequences, whether foreseeable or not. This has exerted the strongest appeal in personal injury cases. According to this school, once the defendant is proved to have been in breach of the duty of care, he is liable for all the direct consequences of that breach. The one who has the whole thing in motion has a lesser claim to sympathy than his innocent victim. Once his conduct is unreasonable, the relevance of foreseeability as a test for liability is exhausted. According to this school, foreseeability is necessary only for the determination of the question of liability. And as put by Lord Sumner in Well, Blundell, and Stevens, foreseeability goes to culpability, not compensation. Furthermore, the consequence must be out of the direct act of the person against whom the action is brought. Directness here includes all consequences flowing in an uninterrupted sequence. This is without the intervention of new forces, human or natural. Therefore, according to this school, the fact that the defendant could not foresee a particular consequence of his act is immaterial if it was a direct consequence. The locus classicus for this test or school is We Polemis, Fairness, Wealthy and Company Limited. Mrs. Polemis and Boyazid, the owners of the Greek steamship Thyracivulos, chartered the ship to Fairness, Wealthy and Company, who loaded in its hold in tins a quantity of petrol. During the voyage, the tins leaked and in consequence there was a considerable quantity of petrol vapor in the hold. At Casablanca in Morocco, it became necessary for the stevedores, servants and charterers to shift some of the cases. For this purpose, they placed the number of heavy planks at the end of the hatchway low for use as a platform. While a sling containing the cases was being hoisted, the rope was negligently allowed to come into contact with these planks and to displace one of them, which fell into the hold. The falling plank caused an ignition of the petrol vapor and there was an outbreak of fire which completely destroyed the ship. The court was of the view that the charterers were negligent in letting the plank fall into the hold. Being negligent, they were liable for all the direct consequences of that negligence, though in nature and magnitude, those consequences were such as no reasonable man would have anticipated. The law lords preserved the rule of re polemis that's the principle borne by re polemis is that if some damage is foreseeable, then the wrongdoer liable for the direct consequences, even if unforeseeable, provided they are immediate physical consequences. Note, it seems that the court created a distinction between immediate physical consequences and immediate other consequences. The former is taken into account, whereas the latter is not. 2. The second school holds that foreseeability is the test for culpability as well as compensation. According to this view, it is not sufficient that some injury to the plaintiff was foreseeable. The particular injury for which a claim is made must satisfy the same test, standing on its own fully. That is, the injury itself must be reasonably foreseeable. This is referred to generally as the Wagon Mound rule. In this case, the appellants were charterers of an oil-burning vessel which was taking in bunkering oil in Sydney Harbour. Through the carelessness of their servants, a large quantity of the oil was spilled into the harbour. The oil was carried by wind and tide to the wharf owned by the respondents, shipbuilders and ship repairers, who were at the time refilling a vessel in the wharf, for which they were using electric and oxyacetylene welding equipment. Some cotton waste or rag on a piece of debris floating on the oil underneath the wharf was set on fire by molten metal falling from the wharf, and the flames from the cotton or rag sets the floating oil on fire, either directly or by first setting fire to a wooden pile coated with oil, and thereafter a conflagration developed which seriously damaged the wharf and the equipment on it. The respondents brought an action to recover compensation for the damage. The trial judge found on evidence that the appellants did not know and could not reasonably be expected to have known that the furnace oil was capable of being set afire when spread on water. In addition, he found that apart from the damage by fire, the respondent had suffered some damage to the spillage of the oil because it fouled their slipways. He considers this damage the direct result of the escape of the oil. The Privy Council, per Viscount Simon, rejected the repolymerase rule as an aberration. They held that foreseeability was the proper test both for culpability and compensation. The council said, "It does not seem consonant with current ideas of justice or morality that for an act of negligence, however slight or venial, which results in some trivial foreseeable damage, the actor should be liable for all consequences, however unforeseeable and however grave, so long as they can be said to be direct. It is a principle of civil liability, subject only to qualifications which have no present relevance, that a man must be considered to be responsible for the probable consequences of his act. To demand more of him is too harsh a rule. To demand less is to ignore that civilized order requires the observance of a minimum standard of behavior. Thus, the principle from this case is that if some damage is foreseeable, then the wrongdoer will be liable for the direct consequences, even if unforeseeable. Within the principles of remoteness of damage will only be compensable where that damage could have been reasonably foreseen by the reasonable man. Thus, the second school seems to be the dominant position. However, Goddard C.J. held in Smith and Leach Brain that the polymerase rule still applies because you take your victim as you find him in personal injuries instances. Please see the principle on causation but for test as held in Barnett and Chelsea and Kensington Hospital Management Committee. You need this principle in support of the schools of thought in the last part we are about to examine. Lastly, let's look at some possible ways in which the chain of causation could be broken. First, novus actus interveniens. No matter which school one accepts, however, the law is that if there is an intervening act which the wrongdoer could not have foreseen, then the defendant is not liable. The chain of causation is said to have been broken. This is often expressed by saying that where there is a novus actus interveniens, then the defendant is not liable. The principle is illustrated in the case of Brandon and Osborne, where Swift J. held that it seems to me that where a person sustains injury through a combination of acts, some done by the defendant and some by himself, it is for the jury to say, regard to the whole of the circumstances where 1. The injury is a natural and probable consequence of the defendant's act, and 2. Whether the plaintiff has been guilty of contributory negligence. If in this case the female plaintiff had been standing in the place of perfect safety and saw, as she says she did, the glass raining down upon her husband and had time to think what was the wisest thing to do, it might possibly be said that she was guilty of negligence by going into the danger. But having regard to the place she was in and the frightening nature of the accident, I think that acting instinctively as she did in clutching her husband's arm and trying to drag him out of danger, she did nothing wrong or anything that can be called contributory negligence. Please see the facts of the case. The second is elections. The courts generally take a liberal attitude of this kind of situation. They say that where a person is put in alternative danger and he elects what to him is the less perilous, the defendant is liable if he is injured. This was established in Jones and Boys. The plaintiff brought this action against the coach proprietor for so negligently conducting the coach that plaintiff was obliged to jump off the coach, in consequence of which his leg was broken. Evidence was adduced to show that the coupling rein was defective. It broke, and to stop the coach, the driver drove to the side of the road, where it was eventually stopped by a post. Lord Ellenborough held that to enable the plaintiff to sustain the action, it is not necessary that he should have been thrown off the coach. It's sufficient if he was placed by the misconduct of the defendant in such a situation as obliged him to adopt the alternative of a dangerous leap, or to remain at certain peril. If that position was occasioned by the default of the defendant, the action may be supported. On the other hand, if the plaintiff's act resulted from a rash apprehension of danger which did not exist, and the injury which he sustained is to be attributed to rashness and imprudence, he is not entitled to recover. The question is whether he was placed in such a situation as to render what he did a prudent precaution for the purpose of self-preservation. Please see the facts of the case. As an assignment to our cherished viewers is to research and send to us the findings on the current development of the law on resultant damage as against or in modification of these schools of thoughts. This is the end of our lesson on general negligence. Please stay glued to this channel for our subsequent episodes. Please don't forget to subscribe, like, write your comments, and help us share. Thank you.